Good morning, everyone.
Morning.
Welcome to this panel's second day of our January case call. I'm Judge Boonstra. I'm pleased to be sitting again with Judge O'Brien and Judge Young. I see some familiar faces. I think you all pretty much know our procedures, but let me just remind you, as we always do at the outset, we know your cases. We've been studying them for quite some time with interest. I think you'll find we know them very well, both the facts of your cases and the legal issues that are presented. So you can just jump right into the substance of your arguments and the meat of your arguments and why you believe you should prevail. We do have a few cases later involving minors. So keep in mind for those cases that we want to protect the minors' privacy interests, and please refer to them by initials rather than by their names. So let's begin with item number 15 on the docket, case number 369048, People versus Flavio Lopez. Hope I pronounced that correctly.
Flavio, I believe,
Flavio,
correct, but I did the same thing, Judge. So I'll pass forgiveness from my
Okay,
client.
thank you.
Your Honors, good morning. It's nice to see all of you again, and Judge Young, you for the first time. I will take those instructions, Presiding Judge Boonstra, and I will keep it narrow. I want to focus particularly on the first issue in the brief, and if the court, however, has any questions about either issues, I'm prepared to answer them. Your Honors, I think the first issue in this case, the jury trial waiver, I don't think often you get an issue that has pretty stark clarity for what happens on the IFCOM. In our view, the waiver, be it by a failure of the court to extract a valid waiver under 6402 or by counsel's failure from a constitutional standpoint, a Sixth Amendment standpoint, to fully inform his client to appreciate the differences between a bench trial and jury trial. Either way, this was not an intelligent and knowing waiver in the way that this court and courts across the country demand. At a Ginther hearing in this case, we learned that my client, Mr. Lopez, the last grade that he passed on merit was third grade. He indicated that he needs help reading documents and understanding documents. It's questionable whether he can really read at all. And when asked about this, trial counsel's answer to whether he knew that was, I didn't know that. You cannot advise a criminal defendant whose liberty is at stake, has all of these constitutional rights, which you guys write about every day, with the seriousness and sanctity of those rights, and then try to fully explain that to someone when you don't know their handicaps. So I don't think you have to do an investigation, and the trial court certainly didn't make any factual findings, but you can just look on the areas of agreement. You know, the PSI and everything about the record here, there's nothing that doesn't corroborate the idea that Mr. Lopez struggles from an intellectual standpoint. Mr. Sharg didn't know that. And what the area of agreement of the testimony was Mr. Sharg gave his opinion on whether or not there should be a jury trial or bench trial. And Mr. Lopez acknowledges that in his testimony. But what there was no discussion of or understanding from Mr. Lopez's perspective is what unanimity meant. You know, what the nature of the right is, what a hung jury could, what the strategy decision could be behind a hung jury, why you may want 12 versus a judge. So
hadn't he been through a trial before, at least one?
Your Honor, he had been through a trial before. He's got a criminal history, no question. But I don't think that sanitizes the idea that this court can feel comfortable that any decision made in that trial was fully informed or not just proceeded because that's the way we go, a jury trial. And this might be the first time he's ever been confronted with that question. Knowing that a jury exists, from another trial doesn't necessarily know you appreciate the differences of what a bench trial might mean from a strategic standpoint. So you're wholly reliant on what your lawyer is telling you, who your life is in their hands, and at that point on the day of trial, you're not changing. You're probably going to go with their advice. That's human nature, and you're proceeding to something that you can't really make an informed decision about because you don't know the differences. So you go with what you're told. And the case law on this demands that there be a inquiry into the unique circumstances of each case. That's Adams versus US, that's Taylor versus Illinois. Fully informed and intelligent, self-protecting waiver must depend on the unique circumstances of a case.
But don't we have a record here that says, at least according to trial counsel, that the waiver was informed? So aren't you asking us to just deem counsel incredible when the trial court didn't?
So the trial court didn't really pass on who was credible or not. He said that the trial court concluded that this was not an error in strategy, that that advice is sufficient. What I'm explaining to the court is you don't have to make that finding because trial counsel didn't know he read at a third grade level or hardly spoke English or could read English, I mean. If you don't know those things, you can't give a fully formed advice without knowing someone's handicap. So I'm not asking you to find that anyone's lying. I'm asking that this was a failure of the court to extract or entertain. I mean, that's not an uncommon question. You read enough plea colloquies, I'm sure, in your work here, that one of the main questions is, do you read and write the English language? I mean, there are a lot of safeguards that were missed here. And I think just the acknowledgement by trial counsel that he didn't know the intellectual handicaps of his client is enough infirmity in informing him to give this court pause as to whether he really knew what he was doing in making the waiver.
So let me ask you a
Of course.
question, because you just highlighted my understanding that his intellectual difficulty was with reading. So how does a difficulty reading equate to a difficulty understanding what his counsel advised him orally?
Well, I think that goes, hand in hand, Judge Boonstra, with, the last grade, him passing on merit being third grade, right? He kept being passed through because he couldn't do it more than 3 times over, and then he dropped out in 9th grade. So when you put these things together, it presents a picture where we can't be comfortable that a lawyer who doesn't know that intellectual struggle is explaining things with the detail and rigor, or not rigor, the detail and simplicity that is required of someone with that handicap. And Mr. Lopez told you, and I recognize you can view that testimony, well, this is just self-serving. He's going to say it now. But the fact that Mr. Lopez, without any leading from his counsel, a tremendous attorney named Ms. Stout, who without leading, offered that he didn't know what hung juries were. In other words, leading to the fact that he was explained that subsequently. So, Judge, I don't think it's just, someone, well, he can't read, so he was explained it orally. We can have comfort in that. I think it's the fact that the court nor counsel obtained this information to advise, and then you have a defendant unimpeached by cross-examination, nothing in the record that says otherwise, that says he really didn't get it, the differences. So putting those things together, Judge, to answer your question, I would say that's what gives you the basis to conclude we're not comfortable that this was a waiver of one of the most consequential rights in American history. I think I want to make sure that this issue, as you analyze it, because the government, I'm sorry, the people and the court analyze this within the framework of just and effective, and I certainly presented it that way because I think that's a huge element of it is the advice between counsel. But I won't concede that any presumption arises that 6402 was followed by its letter. 6402, if it's followed, creates this presumption that that the waiver of the jury trial was valid. But in order to do that, you have to ascertain that he understands the right. I don't think it would be reasonable to conclude that ascertaining the right just involves the question, Mr. So-and-so, do you understand the right? I think it involves more questions than that. It's designed to elicit, does he actually understand the right? And that includes asking about his intellectual abilities. Has he Does he have clear and sound mind? Is he on medication? Has he had an opportunity to ask all the questions of counsel? Does he understand that no one will come in to judge him? And does he understand the rule of unanimity? I think this court has an opportunity to explain what that colloquy looks like. The plea rule does a better job of laying that out. And you've read enough transcripts to know, did I comply with the court rule, counsel? Did I comply with the court rule? Well, 6402 says it has to ascertain his knowledge of the right. The right is more broad than just asking, do you understand the right? I mean, that's kind of bootstrapping to just ask, do you understand the right? Now I've ascertained it. So that question doesn't get to the core of it. So I just want the court to understand and not read this based on the people's response that this is simply just ineffective. I don't think the presumption ever arose. I don't think 6402 was followed in the first place. But even if it was, just on its face, the second analysis then becomes, all right, is that presumption rebutted? And we believe it is. I'll end with this. There are few things, even a bulk of structural errors require some sort of prejudice sometimes under a Chapman analysis. There are a ton of different frameworks under structural errors, but this court has specifically found in Cook and courts across the country agree that this is one of the structural errors that requires no prejudice. It's automatic reversal. That's how sacrosanct, and I don't need to belabor it, but that's.
What do we do with the fact that at the motion for new trial, the defense counsel is questioned, so he knew the difference between a bench and a jury trial? Answer, no question. No question. I would have explained that to him, yes.
That's the question to the trial counsel.
Yes.
I'd answer it the same way, Judge. I take your point. I understand what you're saying is, how do I make a finding different from what trial counsel said? I understand that. What I'm saying to you is that answer, it may be true in counsel's mind, but he also admits that he didn't know the intellectual level of his own client. How can you conclude comfortably, on that someone explaining a right that we study for 7 years and then in the law is in our work is explained to someone at a third grade level when they don't know they're at a third grade level? So I'm asking you not to find him to be untruthful, because I don't think he was untruthful. I think that the fact that he didn't know that, nor did the court, no one really ascertained that he knew the right. And that was the burden of the court and of the rule, to ascertain, to know that he is making a knowledgeable and intelligent waiver.
Not knowing your client's reading level equate to not being able to gauge whether they understand the jury trial right?
I would comfortably say 150% yes. I think that you as incumbent upon a defense lawyer to understand the capabilities of his client.
So
and
I
cater.
agree with you.
Sure.
I think there's no doubt that that's the best way to zealously represent your client, is to understand as much as you can about them, particularly their comprehension. But I also think it's possible to successfully gauge whether someone understands a very narrow topic without knowing their reading level. I think that's actually a relatively common experience in the world, where we interact with individuals and talk to them about things, not knowing their reading level, but being able to successfully and accurately gauge whether they understand what we're saying.
I think that's entirely possible too, Judge Young. But you have my client here credibly explaining and really unimpeached without any cross-examination that he didn't. And he explains why. Because the new information he learned about unanimity and about hung juries and about the workings of Wayne County and jury trial versus bench trial, these are things he didn't know. So you have to read it in conjunction of what he says he understood, which the trial court didn't find to be incredible, didn't really pass on it. I think I guess what I'm saying, judges, these can be read in harmony. I'm not asking you to find that defense counsel is being untruthful when he says that. But I think that on balance, when you review Mr. Lopez's testimony and what he understood to be the case, in conjunction with the fact that the rule requires the court to ascertain whether he understood the right. It's not Mr. Lopez's burden to prove he didn't understand it. It's the court's, duty to ascertain whether he understood the right. And now that we have these questions and these facts, I don't think we can comfortably conclude that we have a man convicted in prison, understood precisely what he was doing that morning in a 10-minute conversation in the hallway. And if that answers all, yes,
I
Judge.
have one technical question.
Yes, Judge.
for you. The convictions in this case were for possession with intent to deliver fentanyl and methamphetamine, I believe, along with felony firearm counts, correct?
There was a coupled with the felony firearms, the drug counts and the firearms. Yes.
Right.
Yes.
And then there was an acquittal or directed verdict of possession with intent to deliver cocaine.
Because of the chemical. Yes.
Judgment
Yes.
of sentence, to my reading, shows convictions for cocaine and methamphetamine. And would you agree we at least, at a minimum, need to send this back to correct that?
You would make an excellent appellate attorney, Judge Brunstra, and yes, if you want me to supplement on that, I'm
You don't need
happy
to
to.
supplement.
But
I
the
just-
answer to that question is yes. I'm not sure how it affects the guidelines, but I imagine they'd be similar because it comes under the same category. But yes, I think at a minimum for a mechanical clerical correction. Yes,
Thank you. very
but that should be with a
much.
with a
I
jury
understand.
trial
I
or
said at
two.
a minimum, right?
That's true. That's true.
All right.
Very nice to see all of you.
Nice to
Thank
see you. Thank you very much. That case is submitted. Item number 16, case number 369087, People versus Corey Terrell Crump. Both parties have waived oral arguments, so we'll be submitting that on the briefs. Which brings us to item 17, case number 374982, Eric L. Van Dusen versus Attorney General.
Morning, Your Honors.
Good morning.
My name is Frederick Stignilson. I represent the plaintiff appellant Eric L. Van Dusen. May it please the court. It's my first time here, so
Well, welcome.
for being a little nervous.
Relax. You're welcome to be here. Happy to have you.
May I reserve 6 minutes for rebuttal?
Certainly.
Your Honors, this case cuts directly to the heart of what the Freedom of Information Act is all about. The timely access to public records so that members of the public can stay informed about the affairs of the government. Where we stand today as a result of what's transpired in the case is that a member of the public, a journalist, was denied the ability to report on a very high publicity trial in a timely manner because he didn't get the records he requested from the Attorney General's office. And then throughout in order to exercise his right to try to enforce it through the statutory provisions of the Freedom of Information Act, he was denied the ability to conduct full discovery in the case and unable to fully vet his claims when there were genuine issues of material facts still remaining. And then ultimately, contrary to really the purpose and the jurisprudence in set forth, he was forced to carry the entire financial burden of the litigation. Beginning with the issue of prevailing party, and we've hammered this pretty hard in our brief as to count one, but just briefly, under Woodman, I think it's clear that the fact that the department was able to redact the social security number as to the first request does not make them a partially prevailing party. Woodman, you have 8 videos in which numerous faces were redacted in each video, and the court made clear that in and of itself, those redactions don't make you or don't change the fact that the plaintiff in that case was a prevailing party, because the standard was the action reasonably necessary to ensure the disclosure of the documents or the public records? Did they have a substantial causative effect? And ultimately, did the plaintiff obtain everything he sought? As to the first request, he sought the exhibits that were admitted in open court during the Jackson County trial of the Wolverine Watchman, as well as the exhibit list. As is admitted, I believe, by the appellant, he's received all those exhibits at this point in time, with regard to that request through a court order. So he has all the exhibits as well as the exhibit list. I think it's a very clear-cut matter that as to count one, he prevailed in full. That reasoning, and this is something that we didn't perhaps described to its fullest in his brief, is that the reasoning from Woodman also underscores that as to the second request, the plaintiff, the appellant, was also the prevailing party. The initial response that came in response to that request, and again, he requested 17 different categories of documents. And as a requester, of course, there's an informational discrepancy. There's a power imbalance when you're the requester. You don't know what you don't know. You don't know what you don't have. So he requested these categories of documents. He initially receives a little bit under 400 records with a very meager 10-page privilege log. He files a suit. And as a result of the suit, he receives an additional 817 documents. There's a 40-page exemption log that I'll get to in a minute, but the fact that he was able to compel that disclosure through his lawsuit makes him the prevailing party under Woodman. The fact that there are redactions, even if this court were to agree with the Court of Claims and say the redactions, the exemptions that are claimed under the exemption log and through Ms. Hageman Clark's declaration, those are sufficient. We agree. There's no more to discuss there. He's still the prevailing party because he had a substantial causative effect on the delivery of those documents. And that's really made clear by the appellee's affirmative defense, number 14, that I know that they'll discuss. We will conduct, as a result of your lawsuit, an additional search for the records, and we'll get them to you. Perhaps more importantly, when it comes to the second request, when this court reviews, and I know you, as you have, reviews the record de novo and reviews everything that has been submitted, it's obvious that there are genuine issues of material fact remaining. And that's because when we're dealing with an unsworn declaration on the part of Ms. Hageman Clark, my client submitted a voluminous affidavit of his own in which he details what he was able to observe as a member of the public in court, but also, and this is where I admittedly below things got a little bit convoluted, because again, it's so hard to explain what you're missing when you don't have what you're missing. And the exemption log, that the 40-page exemption log, yes, it's more detailed than the 10-page exemption log, but it still doesn't tell the requester how many records are being withheld, how many pages of records are being withheld. There are numerous exemptions being claimed for each entry, for each document number. For example, document number 120, which is a Bates stamp 1390, claims a frank communication and personal privacy exemption for an email that attaches a memorandum about Andrew Nichols, which has background info about the facts and circumstances of Nichols' case. The court knows that in order to establish a frank communication, that a public record is a frank communication, or that document is a frank communication, requires first a 3-step test followed by a balancing test. None of that occurred in the lower court. None of it is apparent from Ms. Hageman Clark's declaration. There's no explanation as, for example, to the second prong, that it covers anything other than purely factual material. And really, I think that's been at the heart of the appellant's arguments all along in his complaint, in his response to the motion for summary disposition, in the arguments in the Court of Claims. We need more information to really test this. And that's why the deposition of Ms. Hageman Clark was so crucial to his case. Now, the court may say, well, why didn't you file additional interrogatories? Why didn't you file additional requests for admissions to answer these questions? Well, that would be robbing the plaintiff of his opportunity to litigate the case in the manner that he sees best. That would force him to show his hand and be unable to perhaps attempt to impeach the witness at the deposition, to come armed with a cache of documents and say, why doesn't this fit this exemption? Please explain how this is a frank exemption. Please explain how this information is of a personal nature and why it satisfies the balancing test that's necessary for that claimed exemption. It's impossible to do so based on what's been provided. Another example of this is Bates stamp 1983. It's document number 169. in the exemption log. It's an email from an attorney from the Grand Traverse Prosecutor's Office to an attorney at the Attorney General, Assistant Attorney General Dadamani. They claim personal privacy, work product, and deliberate process. If you look at that document, it's just an email that begins, the entirety of the email is blocked out, and then there's a signature page from the attorney from the Grand Traverse, Kit Tholen, from the Grand Traverse Prosecuting Attorney's Office. What factual information was contained in that email? How would the requester know? How would the reviewing court know? And how can we engage in a proper balancing test required by the frank communication jurisprudence, as well as the privacy exemption jurisprudence with what's been provided? We can't, is the answer. And that's one of the reasons why the in-camera review, in this case, yes, there wasn't a motion filed for it because the appellant sought to depose the de facto FOIA coordinator prior to that stage, but the court should have recognized, the Court of Claims should have recognized that I cannot rule on these exemptions without conducting an in-camera inspection because there's so much that's not there. Turning to the court's ruling on the punitive damages, on the arbitrary capriciousness and the willful intentional withholding of documents. Again, the appellant should have had a further opportunity to question Ms. Hageman Clark, the de facto FOIA coordinator, about what the methodology, what the actions were that were taken, because there are things in this case that are simply, they defy common sense and they defy logic. As the plaintiff alleged in his affidavit, Bates stamp 2431, in paragraphs 41 through 43, while this lawsuit was pending, while they were claiming a FOIA exemption, while they were claiming that disclosure of the exhibits in response to the first request in an unredacted format would violate the personal privacy of those individuals depicted. And again, they were withholding photographs and images of these individuals, which is clearly not covered by the privacy exemption. While they were doing that, during the pendency of the litigation, they displayed those same exhibits in open court in the subsequent Antrim County trial. There's simply no guiding principle. There's no reasoning that would say, hey, if you really believe that these exhibits are, that disclosure of these exhibits under the Freedom of Information Act would result in an clearly unwarranted invasion of an individual's privacy, that you would display them in open court without requesting a protective order, without making any sort of redactions. It defies and it belies the reasoning. And that's why this is arbitrary and capricious. And again, exploring those issues further with Ms. Hageman Clark would allow the appellant to bolster his claims, or at least test his claims. And that's something that didn't happen in this case. Again, if the court, and I don't want to bore you, but I've given you so much information, and there's so many documents, as you know, thousands of pages. But if you compare what was provided initially to what was given as a result of not as a court order where they're fully unredacted, but what was even provided on November 8th of 2023 in response to the first request, Bates stamp 10 versus Bates stamp 905, and where you see an entire a photo array of individuals where the entire thing is blacked out. And then later you see just the pictures, and why? What is the basis for that under the privacy exemption? In this case, unlike the prior case, they did not claim that the ongoing law enforcement investigations or anything would be hampered. That was not even raised. It wasn't raised in the initial response. It wasn't raised it wasn't raised during the litigation. It was always the privacy exemption when it came to those exhibits. And there simply is no basis. And that makes an individual, when you're looking at it, there's no other takeaway than say, what is going on here? Why who is making these decisions? How are these decisions being made, and how can you justify that? And I would submit that you can't, but at least on this record, we don't know because we didn't have a chance to ask the most important individual about it. And I spoke about it, but this is what fate stamp 10 looked like the first time, and this is what it looked like when it was provided later. To the point of intentional and willful, they made clear that they were intentionally and willfully withholding the exhibits. They said it in the appellee said it in the affirmative defense number 14. We'll conduct a further search. And at that point, this is not like in count 2 where they might have had to search for additional information. They knew what the exhibits were. They didn't have to look for them. They had them. This is not an administrative, like there wasn't some administrative burden on them to find it. We're going to wait. They said, we're going to wait till certain things occur and then we'll give it to you, like the Antrim County trial. And that's not a FOIA exemption. That simply is not based. It's not based even in the FOIA exemption that they're claiming, but it's not based in any other FOIA exemption. That is intentional and willful withholding of the document. So when the Court of Claims says that there's no evidence that this was arbitrary and capricious, there's no evidence that this was intentional and willful, that's clear error. Because when you look at the entire record, it's not possible to be left, or it's not possible to look at that and that reasoning without having a firm feeling that a mistake has been made. That all aside, you may say, the court may look at this and say, well, we agree with everything that the Court of Claims. Reason do we think everything has been sufficient? You only prevail, the plaintiff only prevailed in part. This case is still, it's an abuse of discretion for the Court of Claims to deny the appellant at least some attorney's fees. The Court of Claims summarily dismissed the issue of attorney's fees, didn't engage in the analysis of the Purgu factors, didn't even find out what was reasonable. What fees may have pertained to count 1 versus count 2. That may be an inquiry that the court should have made if the court found, if it is in fact true that the plaintiff appellant only prevailed in part. But as you know, I think he prevailed in full in both. But if he only prevailed in part, how is it that on this record, when there's been delay of up to, and on some of the issues, more than a year delay of the public record, to the point where there's no newsworthiness left in the records that were requested? How is it that a litigant who seeks to enforce his statutory right then has to shoulder the entire burden of the attorney's fees? I'm not here saying that necessarily all the attorney's fees are reasonable, but there should at least be some consideration. There should at least be an opportunity to present that information and say, hey, this is where this work was spent. This is where what this applies to. But that didn't happen. It's just, we want to be done with it. We're gonna deny that. And I'll say that, the Court of Claims, the opportunity to argue these cases in front of the Court of Claims is one of the highlights of my career. We had deep, engaging legal discussions to the thing that as a trial attorney, I don't usually get to have. It was amazing. But then when it came to deciding the case, the court really just seemed to want to be done with the matter and not engage in the necessary and relevant inquiries. Just essentially, we just need to dispose of this and let's leave it to a later court. So
You'd agree under the statute, it's an abuse of discretion standard. It's in the trial court's discretion if you prevail in part as to whether to get fees, correct? So your position is that the trial court abused its discretion in not doing?
if this court finds that, if the court finds that the appellant prevailed in part, yes, it is an abuse of discretion standard. And I'm saying that while I don't believe that's the case, even with all that, if you look at the case as a whole, everything that transpired, that was an abuse of discretion, because the spirit of the act is about, I mean, the whole purpose of 240 subsection 6 is to encourage voluntary compliance with the FOIA. That's why there is the issue, that's why we depart from the American rule about the normal by litigants bearing their own burden. It's really the purpose and spirit of the act is to enforce it, voluntary compliance. In this case, there was no voluntary compliance. There was only delay, only tepid excuses. So I believe on that record, Your Honor, that the Court of Claims did abuse its discretion in denying at least some attorney's fees, or at least engaging in the inquiry in and of itself without just simply saying, no, I'm not going to give any attorney's fees. Didn't even hear any argument on what the attorney's fees may have been. As to the cross claim, which has been filed by the appellee, that issue is moot, Your Honor, and I know that's been laid out in our brief. They provided the entire record. It would be essentially unringing a bell. You can't close the door when the walls have caved in. There's no way that this court could offer the remedy that the appellee is seeking if you granted their appeal. And so that at that point is moot. I just want to circle back here before I sit down. There's an argument too that's made by appellee that is the court should view this as an action as a whole. That because there are two different FOIA requests that are being challenged in this, and responses that are being challenged in the single litigation, and he prevailed in full on one count. Then if he didn't prevail in full on count two, then the court should say he only prevailed in part. The practical implication of that would really render an absurd result, and it would render a result that litigants who would be encouraged to file multiple lawsuits when they could permissively join their lawsuits. So the court is encouraged to view those two requests separately as separate actions under the Freedom of Information Act, because otherwise, if he had filed two separate lawsuits, he would be entitled to attorney's fees under his first request. And if the court finds he was only prevailed in part as to count two, or it'd be count one as the second request, and the Court of Claims was right, then he would be denied that. So that can't be the policy of this court, to encourage additional filings, to encourage more litigation when judicial economy is so heavily stressed, not only in the court rules, but also in the courts, in all the court's jurisprudence. Does the court have any other questions of me this time?
If we agree with you that as it stands now, you were the only prevailing party for count one, but then we also agree on the cross appeal, then that sort of puts us in a situation where we count, where you might then be, or you would probably then not be the only prevailing party anymore, right?
Thank you, Your Honor. I would say that the answer would be that the court would, the request would be that the case should be remanded for further investigation. As we've discussed, when it comes to the privacy exemption that's claimed with regard to the Facebook IDs, with regard to the names and everything, or with regard to the dates of birth, the addresses, there's far more. The court dispensed of it because of the way that the exhibits have been handled, because they've been displayed openly in public court. I think the court should have reached that finding based on the public domain doctrine that these public records had been displayed so that the claimed exemption has really no effect whatsoever. The court didn't do that. But even under the privacy exemption, there's not enough information in the record for the court to make the finding that the people, or that the appellee has substantiated their burden, because at the Facebook IDs, we don't know who did they belong to. Is it still an active Facebook ID? And that would be the inquiry that goes to finding whether it's even information of a personal nature, which I submit that it's not. Now, the date of birth it may be a different inquiry, but that's the inquiry that we can't make on this record without additional information. So to answer, I guess, I don't know if that was too circuitous, Your Honor, but I would say that the remand would be appropriate for further proceedings, because there would be genuine issues of material fact as to count one.
Hey, counsel, you have your 6 minutes and maybe even a couple more for rebuttal. So let's hear from the other side and
Thank you, Your Honor.
you can come back. Response?
Morning, Your Honors. May it please the court. Assistant Attorney General Adam DeBear appearing on behalf of the Attorney General. And I'll do my best to focus on essentially some rebuttal points to what appellant's counsel pointed out, and then I'll turn to the cross appeal, and I'll move as quickly as I'm able. I want to note at the outset, one of the first things that was presented in oral argument was that the department caused a delay in providing these trial exhibits that prevented a journalist from reporting upon a highly relevant public trial. It's in the briefing, it's in the appendix, but Mr. Van Dusen sat at the trial in Antrim County every day of the trial. He recorded it, including the exhibits that were come up. So this isn't really, I don't think, appropriate to point out that, or to argue that the department prevented him from publicly reporting on a trial that he personally attended and videotaped. With respect to discovery, and there's a lot of FOIA case or federal FOIA case law that we point out in our briefs, but essentially discovery in FOIA as a general matter is rare because typically the departments can provide a complete particularized justification in the manner of evening news and the corresponding federal cases. And it's even rarer in a case when the subjects of that discovery are prosecuting attorneys. This court's opinion in Messinger versus Ingham County prosecuting attorney, I believe is the case name it's cited in our briefs, basically stands for the proposition that it's discouraged taking discovery of prosecutors in these types of cases. And it was the holding in Messinger was echoed in this court's opinion in King versus, I believe, the Oakland County prosecuting attorney's office. I believe was a 2013 opinion. Essentially, there's published case law from this court that we don't take discovery of prosecuting attorneys where they're forced to give answers about their work product. And here, with the detailed nature of the exemption log, really the only thing that Danielle Hageman Clark could be testifying to is what the investigations consisted of, what the documents stated, and any answer that she would give would be necessarily intruding into that work product conduct that, again, this court says we're not supposed to be taking prosecuting attorneys' depositions in these matters. With respect to the claim that plaintiff prevailed in full and also to the mootness claim for the cross appeal, Judge Young, I think you answered it correctly. If this court were to remand the matter, there would be an active case for controversy that would eliminate the mootness. Now, indeed, in State News versus Michigan State University, Michigan Supreme Court case 481 Mich 692 does state that if, it's a footnote 25, that if you release a requested public record, it moots out a potential FOIA appeal. But when the matter would be going back for a question on attorney's fees, reversing the trial court's determination that we claim is erroneous, that plaintiff was entitled to this information, would have an effect on the court's determination of the attorney's fees issue. And I'd also point out this court's 2004 opinion. The procedural history is a bit odd because it is a FOIA case titled The City of Warren versus the City of Detroit. Stands that even public bodies can submit FOIA requests, presumably. But essentially, in that case, this court noted that the defendant, the City of Detroit, produced information that it maintained was exempt from disclosure. And this court still reached the issue on appeal, noting that it recognized the issue presented in that case has public significance and is likely to recur. This court has only had the benefit of one, Eric Van Dusen versus Attorney General case. Judge Redford has had three at the Court of Claims. This is an issue that comes up frequently. The department prosecutes a handful of cases, and it is an important issue whether, setting aside the fact this information is displayed at a public trial, whether in a FOIA request, the department needs to exempt information that would meet the criteria of MCL 15243-1A, FOIA's personal privacy exemption. Indeed, there was additional redactions that were made before the litigation started, but But at issue in the litigation, we only redacted those specific categories of information. We redacted addresses, not of the criminal defendants, but of, sort of witnesses whose names appeared in the documents. We redacted dates of birth, which, as this court knows, the Michigan Supreme Court says you can't submit in court documents dates of birth. We also redacted home addresses, the dates of birth, telephone numbers, all subject to binding Court of Appeals opinions and Supreme Court opinions that said that information is information of a personal nature. And then we also redacted Facebook ID numbers, which we explain the basis for that redaction and maintain that they are also information of a personal nature. I guess I'd said I'd end with the cross appeal, but just getting it to it right now, the Supreme Court's opinion in Michigan Federation of Teachers was clear, and in my opinion, it's binding in two respects. One, it notes the possibility that even though information was disclosed elsewhere in the public domain, that doesn't mean it's not exempt under FOIA. And it also says that information such as addresses and telephone numbers, it cannot shed light on the inner workings of government. As this court is most likely aware, in the elections case or in the elections setting, that's a little bit different because people do have an interest in making sure that the election laws are properly maintained and administered. And sometimes addresses are important in that realm, but they're not important here. Nothing in the addresses, nothing in the redacted Facebook ID numbers, nothing in the dates of birth shows how this prosecution resulted, because again, it's not the criminal defendant's information who was obtained. You still have the entirety of the subpoenaed records from Facebook being produced, just without those Facebook identification numbers. Quite simply, there's nothing in that information that could shed light on how this prosecution unfolded. And therefore, under the Michigan Federation Teacher Supreme Court case, it is binding case law that it is not, disclosing that information would result in a clearly unwarranted invasion of privacy. And then again, just with respect to prevailed in full, one of the key components about whether a party prevails in full is whether the action had a necessary causative effect on the delivery of information. Count one, Mr. Van Dusen, again, was at this trial the whole time and saw all of the exhibits in person. And also, when asked about the information that he obtained independently from this lawsuit and the sources of that information, he refused to provide an answer, citing his journalistic privileges under the First Amendment. But again, that's plaintiff's burden of proof to show that they prevailed in the matter. And if it's his burden and he's not answering the necessary questions to show whether he had this information, it's essentially the same as forfeiting that issue at the trial court level. As to the second count, the department prevailed in large part. As this court is aware, the entirety of the exemptions invoked by the department were upheld based on the privilege log over 80 instances of non-disclosure. And in that regard, we substantially prevailed. At the outset, it's in our briefs, I know the court's aware, but we did alert Mr. Van Dusen when he was acting pro se that we would be conducting this subsequent review. I don't believe that the department waited until after the conclusion of the Antrim County trial to produce the counts in count one. The record will correct me if I'm mistaken. But in this case, Judge Redford had already ruled in the first lawsuit that Van Dusen filed about different criminal trial exhibits that our arguments in that case were, unsuccessful, and we produced it after Judge Redford's opinion in case one. I don't believe we waited until the trial in Antrim County finished. But also, we did, as promised in our answers and affirmative defenses, conduct that subsequent review, which took time because there were over 160, I believe, records to review with multiple pages. And just because the specific records were referenced on the document review by appellant's counsel, I think it's worthy for this court to note that for the work product invocation in record 169, communications between an assistant prosecuting attorney from Grand Traverse County and an assistant attorney general, Sunita Dodamani, we explained in the basis for exemption This is an email communication between APA Tholen and AAG Dodamani in which Tholen explains his thoughts and opinions regarding a potential plea offer to Andrew Nichols. We also explain that a redacted copy of the email along with the attachments are being produced. And we also noted for the court that the attachments to the email are publicly filed documents that contain minimal redactions to the information enumerated in MCR 1109 D9A, which is the redactions on personal privacy. That was sufficient for the court to draw a conclusion as to whether work product applied. Why? Because it was one attorney communicating to another attorney about a shared case or a shared investigation, his particular thoughts concerning the prosecution. Another record that was referenced was record 120, which again, the basis for exemption in that case explained that it was a transmittal email containing an internal memorandum in which AAG Dodamani requests plea authority in a criminal action filed against Andrew Nichols, along with background information regarding the facts and circumstances in Nichols' case. In the memo, AAG Dodamani sets forth her opinions and recommendations regarding potential plea offers for the defendants in advance of a final decision to be made by the then Solicitor General. That was enough information for Judge Redford to make an opinion or decision as to whether work product and attorney-client privilege applied. In the FOIA and in case law, in-camera review is discretionary. It is not mandatory. The plain language of the FOIA says that a trial court may conduct in-camera review if necessary. And indeed, the very language of Evening News says that typically you should stop at step 2 or at step 1 if the department receives a complete particularized justification. That 40-page exemption log contains explanations for each instance of non-disclosure that we contained. Judge Redford doesn't have to look at the documents when he has a declaration under oath from the department's chief, prosecuting attorney containing an exemption log that identifies in particular each specific instance of non-disclosure. And so for that reason, when we prevailed in large part, albeit plaintiffs prevailed in some part, Judge Redford had the discretion, as Judge Boonstra noted, to either award fees or not. We don't need to get to the second level of the attorney's fees analysis where you go through the 8 factors because there isn't a mandatory award. Judge Redford exercised his discretion and declined to award fees. And he noted in his opinion several reasons, including the voluntary disclosures throughout the litigation. I don't think you noted it specifically, but again, the department noted before Mr. Stig-Nielsen had joined the case as Mr. Van Dusen's attorney that we would be producing these records. And again, Judge Redford was aware of the fact that Mr. Van Dusen was present for the entirety of the trial in count 1 and saw the exhibits being admitted in real time as well. So there's a plethora of additional reasons within the appendix, as noted in our briefs, that support Judge Redford's discretion to decline attorney's fees in this particular case. Unless the court has any other questions regarding this case, I would just ask that this court issue an opinion affirming the trial court's quashing of the subpoena for Danielle Hageman Clark's deposition, affirming its denial of punitive damages, civil fines, and attorney's fees, and affirming the trial court's decision to decline to conduct in-camera review because, again, that discretion was provided to the court by Supreme Court precedent and FOIA. And as to the cross appeal, we would ask that this court issue an opinion reversing Judge Redford's conclusion that the personal privacy exemption doesn't apply to those narrow categories of information. Thank you, Your Honors. I appreciate it.
Questions? Thank you very much. All right, rebuttal.
As to the first issue with regard to if the court were to agree with the cross appeal, First, let me clarify that the Antrim County trial took place on August 24th, 2023. That's found in the the plaintiff's affidavit, pages 243, 240, or 2004-31, 2004-32 in the bait stamp. The production occurred on November 8th, 2023. So they did wait until long after the Antrim County trial to produce those exhibits. The production, if the court compares the production that was made on November 8th, 2023 to what was initially produced in November of 2022, the court can still find, or should still find under Woodman, that the plaintiff was the prevailing party. Because again, the ultimate issue of whether there's some redactions or some portions of the public records that can be withheld, as admitted by the appellee in their affirmative defense and today, the filing of the action had the causative effect on the subsequent review and then the subsequent production of those records. They would not have done that had he not filed the lawsuit. They would not have given him the lesser redacted versions. Those lesser redacted versions in and of themselves are still everything that he initially sought. And that's perhaps a point that should be clarified. And the court knows this. Under Woodman, it's not what is squabbled about in the litigation. It's what is requested in the actual FOIA request. He never requested in this FOIA request completely unredacted exhibits. He requested the exhibits that were displayed in open court and the exhibit list. The November 8th production that occurred as a result of the litigation satisfies that request. So under Woodman, he's still a prevailing party. And so even if the court were to agree with the cross claim, I don't think that you need. My client would love to go back and have the opportunity to continue to litigate these issues because these are important issues, but the court doesn't have to completely agree with the request for relief. You could find he's the prevailing party under Woodman and that he prevailed in full and order the attorney's fees. If you look at, there's a supplemental affidavit that was filed by Mr. Van Dusen on the 20th of January that was submitted at the time of oral arguments. It contains 5 different versions of what we call the Igloo. It's a Facebook account, and it shows you how over time the redactions were whimsically made. And so that's why in this case, while discovery is rare, this is an extraordinary case. There few, if any, FOIA cases have ever shown a public body acting in such a disjointed manner when it comes to treating public records as this one. And that's why further exploration of what is the methodology, what are the reasons for these actions is necessary. And so as the court knows, we're asking that the court reverse the trial court as to the granting the motion for the protective order. And I guess I would just reiterate that the declaration wasn't made under oath. It's not a notarized declaration, and this court has sua sponte authority to disregard an unnotarized declaration as is laid out in your jurisprudence. Whether or not the Facebook IDs are a matter of personal nature, that is a question of fact. And whether you give the plaintiff the opportunity to resolve that issue in the lower court or not, he's still the prevailing party as to count 1 and count 2 in this action. Thank you for your time.
Thank you very much. Any final questions? Appreciate your arguments from both of you and your briefs. Very well done. And we will give the matter appropriate consideration and issue an opinion as soon as we can. All right. Nice to meet you. Welcome to the Court of Appeals. And that case will be submitted. Moving to item 18, consolidated cases 370783 and 370803, Estate of Miracle Jamerson versus City of Detroit. Yes, Mr. Kamenik is here in person. I believe Ms. White will be appearing remotely. All right. Morning, Ms. White. Can you hear me?
Yes, thank you, Your Honor.
Thank you. I believe we have an appeal and a cross appeal. Mr. Kamenik, you're the appellant on the main appeal, correct?
There's two main appeals, but either way, I assume the court's going to ask us to argue both issues at the same time.
That would be great,
Of course.
yes. But I think you're probably up first.
I'm only gonna go first. That's
All
great.
right.
Good morning. May it please the court. My name's Rob Kamenik. I represent the plaintiff on both the appeal and the cross appeal. Happy New Year to each of you.
You.
This is not my first oral argument, by the way. I'm assuming that the panel is familiar with the facts of this case as usual. But, you know, I've always learned when you start off a presentation, whether it be a speech or the like, you know, throw something out there that gets the court's attention. So when I first picked up this case and I was involved in the trial court level, you know, what I was asking myself is, when is a police pursuit case not really a police pursuit case? That's sort of what we have here. This is I could not find another case like this. Obviously, and I'll get into it, a lot different than Robinson. But here, I'm sure the court saw in the briefing that the city itself concluded that in the force investigation report, that it was outside the scope of articulable, reasonable suspicion or probable cause. Pretty powerful statement to be made. Why exactly did these officers start chasing the Dixon vehicle? Matter of fact, and that's in the appendix at 211A if you're interested. When the force investigation also reveals that Officer Zamey said initially that he didn't even believe that he was doing a police pursuit, which I found very strange statement. But the court knows that there were 6 departmental violations, 5 were sustained. And the court also knows, and I'll get into the pertinence of this in a moment, that here the sirens were never activated until after the accident. The lights were not on. And there's, quite frankly, no evidence in the record at all that the Saturn vehicle, which my client was a passenger, was speeding. So, you know, the first issue, and I think is the resulting from issue, the motor vehicle exception. And what I'm suggesting to the court is you have facts that are so far removed from Robinson, it's as if it's in a different universe. Robinson was a case that the court is familiar with. You had 2 stolen vehicles in Robinson and Cooper. In each case, there was a pursuit, but there was a pursuit with cause. And in one case, I think it was Cooper.
I don't know that this case is one where speak for myself, that I really question whether the individual officer was negligent so much as we have concern about causation. So let's say we're totally with you. This is abhorrent, unlawful, all the bad things, behavior on behalf of the police officer. But with respect to the motor vehicle exception, what do we do about the fact that there's this intervening cause, the running of the red light, the car accident that did not involve the officer? That at least for me is what I am struggling with.
Well, I just want to make sure I'm addressing your concerns, John. There's really 2 issues we're talking about. And the way I heard it, you might have intermixed too, but maybe I've got it wrong. The resulting from is whether the motor vehicle exception applies.
Right.
And
How do we have resulting from here?
Oh, fair. I just want to make sure we're not talking about the proximate cause yet.
No,
Okay.
but that's an
Well-
interesting question too.
We'll get to that as well.
I
So
think the resulting from standard is at least with post Robinson cases, stricter in some ways than the proximate cause. You supplied some supplemental authority that sort of gets at that too, where and maybe that's what the trial court was recognizing as well by keeping alive the gross negligence, but not the, like resulting from, I think is more of a but for.
Let me see if, I don't mean to interrupt. Let me see if I can clarify a little bit. And let's just go back to what the trial court did and then work backwards. The trial court found for motor vehicle exception. We're not getting to the individuals yet. We're talking about the city alone. The trial court found, as I read it, that since there was no contact between the police vehicle and Mr. Dixon's vehicle, that therefore the motor vehicle exception didn't apply because resulting from required either that the police car hit or physically force the other vehicle either off the road or into another collision. That was my understanding of the trial court's ruling on resulting from, and that generated our application for leave and also the cross appeal.
Well, it's not so much, I mean, yes, of course, the vehicle didn't physically hit, and I understand that the trial court recognized that. But the trial court also said that didn't otherwise physically force the car off the road and into another vehicle. So why were they wrong about that?
Well, my first line of argument, which is in the brief, is we don't have anything near a Robinson case. We don't have a Robinson case.
I
Why?
get that, but that to me
Okay.
gets at before we get to causation.
No, bear with me, Your Honor. I'm trying to say that when you're going to interpret what means resulting from, and you take it from Robinson, the facts are so globally removed that the Robinson rule shouldn't apply. That's the first argument. Whether the court accepts it or not, I understand that. Because quite frankly, again, and I'll try to address the questions as they come. Quite frankly, when you read Robinson and the way the court, with due respect to the Supreme Court back in 2000, the way they define resulting from is quite frankly bizarre. No case in the country I have found defines resulting from in that fashion. I know I'm in the Court of Appeals.
I was just gonna say,
I
you
know.
know, we can't do anything about that,
I know,
right?
I know. And I also understand my limitations and how far I can push the court and wait until we get to the proximate cause with your favorite issue, Your Honor. Okay, so I've got that. But I do think that there is still an argument to be made that, as I started off, is this really a pursuit case? And if it's not really a pursuit case, why should we go with Robinson in the first place? You can accept that or not. I
Okay, can you
understand.
accept that if we apply Robinson, that resulting from is not met here?
No, well, I can't accept that because that's why I'm here. You know, and again,
Well, that doesn't ruin your.
well, let me get it. I understand where we're going with this. So, in Robinson, we had, situations where hitting or physically forcing the other vehicle wasn't pled, and there was no evidence whatsoever that there was contact. That's what you had in Robinson. Here, you don't have hitting. I agree with that. But you have to ask yourself, what does physical forcing mean if it's not hitting? And I struggled with this when I wrote the brief. I'll be very candid with the court. What exactly does that mean? What circumstances does that entail? So of course, just like the Robinson court did, I have the prerogative to go to dictionary definitions too. And I gave the court also a definition, a legal definition, but more importantly, a common definition. And that's to make something happen by way of force. Okay, the force here was movement, was speed. That's the force. Now, whether that is enough to constitute physically forcing is the question for the court.
That different from Robinson.
Robinson,
Police chase there as well, right?
but in Robinson, it wasn't even pled. The court just went down the road as I understood it. That's a good question, if I may. Is my understanding, Robinson just went down the road of saying there wasn't hitting. But again, if physical is meant to be something different than hitting, what is it? Robinson court didn't address that. And the cases that I looked at, I couldn't figure it out. And rarely do I stand at a podium and tell three judges that I can't figure something out. I do it at home quite often, but that's fine. But the fact of the matter is, I did not, and maybe I missed it in the case law, a good definition of physically forcing. Here, yes, you have completely different facts. You didn't have a legitimate police effort at all, anything along these lines. So the best I can give you, Your Honors, on that is I do believe if you look at a dictionary definition of physical forcing, that it deals with the use of force, and that can be movement, that can be speed. I can't answer the question vis-a-vis Robinson. Court didn't analyze it. I understand the concern, however. What I would encourage the court to do, however, knowing that this is the intermediate appellate court, look at all the cases that I cited in the brief that talk about resulting from. Some jurisdictions define it broader than but-for causation because it takes into account multiples. Every case I've got said that here's how it works. If it's not statutorily defined and resulting from is not statutorily defined, then the default is ordinary plain meaning. It's a mystery to me how you can claim this accident, this event, wasn't the natural and foreseeable consequence of what these police officers did. So that takes care of it on resulting from and the cross appeal issue. I'll answer any questions on both issues as I go. The city's appeal is on the proximate cause with respect to Officer Zamey. Now, we know that Judge Hughes went ahead and found that there was a question of fact in this. I don't know if that's exactly the right way to put it, because it's very interesting about when you look at Robinson, you look at Ray, what exactly is going on with the test. Judge Boonstra, I know your opinion on remand and Ray, and you raised a bunch of good questions, but I can't answer those here. I've got a client here today, and but I will say this. Ray is the governing law at this point. Now, how we figure it out is part of, if I may, Your Honor, part of your issues. But interestingly, when you go into the city's brief, they cite Ray, but they don't apply it. They don't apply it at all. So I'm going to take the prerogative of applying it. So the first, it's under Ray, there's a sequence of analysis that you go through. Okay. And the first deals with whether or not you basically have proximate cause at all, a proximate cause. And here, I don't think there's any debate on that. Really, for you to say that there no proximate cause, again, this is something Judge Boonstra, you brought up in your opinion on remand. You'd have to say that the accident, that somehow the activities of Dixon or the accident were a superseding cause. And they weren't. They were fully foreseeable that this would happen. Think about it. You've got the police, unidentified, chasing a vehicle through city blocks at 55, 60, 65 miles per hour. All the record information indicates that at an absolute minimum, there's a question of fact of whether Nick Dixon, the driver, had any idea this was the police, and for good reason, because the lights were not on, the sign was not used. And a point that I had learned when I looked at this case, they used a spotlight not on the license plate, but in the cab. Think about a spotlight coming into your cab at night, because it's January, about 9:30, and it's going into the cab. What does it hit? It hits your mirror. You can't even see behind you with a spotlight going on the mirror. Just think about that. So here's Dixon going, what's going on? I'm being chased. I don't know it's the police. I have no idea. So under Ray, Zamey's conduct is a factual cause. That's the first step. And I don't think there should be any debate on that. You determine the other proximate causes, and now we're going to start doing the balancing that Ray requires. The other proximate cause that is identified by the city is Dixon, the driver, and the fact and pointing to his conduct and that he took a plea for manslaughter. And the court, that's all of record here. So let's start going down the weighing of what goes on here. You've got the police chasing somebody down. They have a civic duty to identify themselves. They didn't do it. They precipitated the entire incident. Dixon testified that if he knew the police, he might have stopped, but nobody would have reason to stop here. Again, I'll go a little off the record. When I started law school, I was serving subpoenas in Detroit. And I'll tell you, if I had somebody chasing me and unidentified, I wouldn't have stopped the car either. I would not have gone through an intersection. I would not have stopped the car. That's why this case is so different than every case that I could find. And Dixon testified and he said none of this would have happened if defendants had turned on the lights and then they would have never chased me. And I think that's really important. So Zamey had a civic duty. He took an oath. He violated it. You've got misconduct of the yin yang here, if I can use that phrase. And when you go to the two tests in Ray, we'll go to who's most responsible. And I would say it's Officer Zamey. If it's not for Zamey's conduct, none of this would have happened. He's a trained professional. I'm assuming the court had the same questions I had looking at this case. Why? What was going on here? Were these officers joyriding? There was a civil rights allegation in the complaint. Is that why they put the spotlight in the car to see the demographics of the drivers? We don't know. We really don't know what's going on there, and I guess that would be a question of fact. But he has the greater responsibility. The next test is it foreseeable? I think that when you're chasing somebody unidentified, 65 miles per hour, it is fully anticipated that you could have a traffic accident. The other thing about Ray that I think is important is we're not that far off of the facts of Ray. So remember the facts of Ray, and Your Honor, you can recite them to me better than I can.
Been a while, so refresh my memory.
That was the high school cross
Cross-country
country,
runner,
right?
yep.
And I think he's telling his team, go ahead. And I didn't know what a red-handed pedestrian sign is. I guess it's on the signal when the hand is red. I had to look it up last night. But so there was a red and an automobile comes and clips and hits tragically one of the students running it. Sort of the same situation here, but for what that coach did, these people never would have been in that situation. And in Ray, that was enough. That was enough to create a question of fact. So on the cross appeal, I would ask the court to reverse unless you have questions. I'm not going to belabor all the facts of this case. You've got them. And on the main appeal, I'd ask you to affirm. Let's send it back and see what a jury does with this. Yeah, if I misspoke, logistics and terminology. On the proximate cause issue, I'd ask the court to affirm, to be clear. On the resulting from motor vehicle exception, I'd ask the court to reverse. Sorry about that, Your Honor.
Fine, thank you.
And if I can have a few minutes for rebuttal, at least on the cross appeal, I don't think I took that long, did I? All right. Thank you, Your Honor.
Thank you very much. Ms. White?
Good morning. Good morning, everyone. Sherry White on behalf of the City of Detroit and Officer Zamey, who we are representing. City Council has denied indemnification and representation, but we are representing him for purposes of this appeal. The one thing Mr. Kamenek does not want to talk about is Mr. Dixon, who is in prison for manslaughter 10 to 15 years. There isn't any question that he is the one most efficient and direct cause preceding this. He ran red lights. There's just no question here. And it's also undisputed that there was no contact. So on the resulting from, Judge Hughes made the correct decision. As far as the proximate cause, the city and Zamey were not the proximate cause of this horrific incident. It was Mr. Dixon. And with regard to Ray, as I pointed out in my brief, we don't even have cause in fact, much less proximate cause, much less the proximate cause. Plaintiff hasn't gotten over any of those hurdles. And with regard to the cross appeal on conspiracy, as Judge Hughes said, plaintiff had, talked about alleged policy violations and so forth, but there's nothing to show any sort of conspiracy, and the city itself can't conspire with its own employees anyway. So, so we would ask that the court affirm on the resulting from issue, reverse, and enter judgment for Officer Zamey on the proximate cause issue, and affirm summary disposition also on the civil conspiracy claim on the cross appeal. Are there any other questions?
No questions. Thank you, Ms. White. Appreciate that. Any rebuttal, Mr. Kamenik?
Last words. On the proximate cause question, Ms. White argued that there's no proximate cause to begin with, so you don't go down the sequence of events on Ray. That's not true. At the time of the accident, Officer Zamey's gross negligence, remember, was never contested. It was still in effect. It wasn't like it ended, okay? It was still ongoing at the time of the accident. So the other causes were concurrent. And they certainly were not superseding. That would be the only way to cut off causation. Okay. So that's the first point, cause and fact. Second point, I have not forgotten Mr. Dixon, and I understand Ms. White's argument, but what Ms. White doesn't take into account is the fact that they have not contested Officer Zamey's conduct. So remember, we're talking about a civic duty. We're talking about somebody that, again, your guess is as good as mine about why he was hassling these people. He didn't have any, I started this off saying he had no probable cause at all. And that's not my determinations, that's the city. Why did he start any of this stuff? We still don't know. We still don't, and I'm not being critical of Ms. White. We don't have an answer to that. Maybe the jury would come up with an answer to that, but we do know he did a few things. He violated traffic laws left and right. Officer Zamey did. He violated at least 6 departmental rules or regulations. It was sustained misconduct, and that's the other thing going to the notion of proximate cause. They said it was sustained. It wasn't just for one instant, then it stopped, and all of a sudden you had the auto accident. It was still in effect. So I do think you get to all the factors in array. I do think that the court, and that's exactly where Judge Hughes went in her transcript. She went all the way down the factors, and I think she got it right. So at an absolute minimum, I think that court should find this a question of fact on that. Again, we all know that under Ray, we're not talking about competing but for causation. We're talking about legal responsibility. And so we're really comparing legal causation versus legal causation. I know your theory, if I may, Your Honors, if I read it right on, if you basically go down the road of a comparative but for. That was my understanding of where you were on your opinion on remand, but I don't.
Honestly, I have to go back and read it.
Okay, well, I thought it was very well reasoned, but I don't agree with it.
Yeah. So the point about Mr. Dixon, it raises an interesting issue of kind of an intersection between criminal law and the civil law. Does his conviction necessarily mean that police officers' conduct can't be the proximate cause? I don't know the answer to that.
Well, I don't think so, because let's go back to what happened with Officer Zamey. They went ahead and asked for a warrant to be issued, and the Wayne County Prosecutor's Office said there was insufficient evidence. I don't believe in coincidences. I think that's a little strange. So we don't know if his conduct as evaluated by a jury or judge will be at the same level as Dixon's conduct. We don't know. It's not just it's not as if Zamey was tried and there was a finding of not guilty. You know, his conduct, um, again, I'm reiterate, I have not found a case like this where an officer did something like this. I've seen it where officers acted intentionally, but this is a whole different kettle of fish. So that's the best answer I can give you.
Questions? Thank you both very much. Appreciate your arguments.
Thank you, Your Honors.
Case will be submitted. Cases will be submitted. Moving to item 19, case number 372-596, Kate McClory versus Ryan McClory. Both counsel are endorsed and both counsel have waived arguments, so that case will be submitted on the briefs. That concludes our 10 o'clock call. And we're going to take a short recess before we resume for our 11 o'clock call. All right, we're going to move right on to our 11 o'clock call, beginning with item number 20, case number 374-952, Lucius Conway versus Warren Evans.
Good morning, Your Honors, and may it please the court. I want to first explain that my covering is part of me as a Tewahedo monk and Ethiopian tradition.
Okay.
Okay.
Before you begin, let me make sure we have everyone here. What's your name?
Lucius Conway.
You're Lucius Conway. Okay, welcome to the court. We also have counsel for the defendant appellee appearing remotely, I believe.
Yeah.
Okay. So Mr. Conway, I don't know if you were here when we began, but I always just remind everybody, and I'll do the same again with you. We have read everything that you filed. We're very familiar with your arguments and the facts of your case, so you can keep that in mind. You don't really need to start from the beginning and tell us what your case is about. You can kind of jump right in and tell us, you know, why you think you should prevail on this and what your best arguments are, whatever you want to raise today in addition to what you filed in your briefs. Okay?
Yes, Your Honor.
All right.
Thank you so much.
You may proceed.
Thank you. I'd like to reserve 10 minutes for rebuttal for each of the defendants, if I may.
You get 10, well, you get up to 30 minutes total.
Okay, well, I want to reserve 10 minutes so I can rebut each of them.
Then you,
5 minutes each.
okay.
Okay, but this is not going to take anywhere near
Okay.
20
Usually
minutes.
doesn't.
Okay.
All right.
All right, so we're here today on the fundamental question of whether or not a trial court may defeat its own subject matter jurisdiction by disregarding good faith allegations of damages that, on the face of the complaint, meet Michigan's statutory threshold for circuit court jurisdiction. It is the appellant's position, consistent with Hodge versus State Farm, independent tort claims. The court must evaluate each claim. So the binding precedent in Michigan states that where a complaint pleads both contract and independent tort claims, the court must evaluate each claim separately and give effect to the damages pleaded in good faith rather than subsuming tort claims into a contract theory or artificially limiting the amount in controversy. Any contrary approach misapplies Michigan law and constitutes reversible error. I therefore respectfully ask this court to reverse the dismissal and remand with instructions that the trial court recognize its subject matter jurisdiction and proceed to adjudicate each pleaded claim independently on the merits.
Right.
No questions?
No questions right now.
Very
Thank you
good.
very
Thank
much.
you.
So we have two defendants present, one remotely. Who's going to go first?
Jacob, is it all right if I go?
You said you want to go first?
Sure.
That's fine with me.
Morning, Your Honors. May it please the court. Zachary Matzo on behalf of Wayne County and the individually named Wayne County defendants. This case is a simple matter involving an agreement to arbitrate. That was the motion for summary disposition that was filed. That was the motion for summary disposition that was granted. And Wayne County remains ready, willing, and able to arbitrate pursuant to the settlement agreement that both Wayne County and the appellant signed in this matter. Pursuant to 2.116C7, the lower court was well within its right to grant summary disposition based on the existence of an arbitration agreement. Paragraph 9 of the settlement agreement that the appellant and the county and the union were party to, subject to Mr. Conway's separation of employment, states that if a dispute arises as to the enforcement or interpretation of this agreement, said dispute shall be resolved through the grievance and arbitration process set forth in the CBA between the employer and the union. That's appellant's appendix C at page 18. There's no dispute that the appellant, the union, and Wayne County are signatory to the agreement. And there's no dispute that this is 100% rooted in the amount paid to the appellant pursuant to that settlement agreement. And honestly, Your Honor, based upon your statement prior, I don't really have anything to add at this point. I'd be happy to answer any questions if you do have them.
I would just ask this, I guess I think the arbitration issue was an alternative grounds that the trial court gave. And the first grounds had to do with subject matter jurisdiction. Do you have anything you want to add?
Absolutely.
Okay.
While I respect the trial court's ability to make decisions on their cases before them, I think it was handled in an unfortunate manner, as the argument made in our summary disposition in motion in lieu of an answer focused on the settlement agreement issue, and the amount in controversy issue was not something that we brought to the forefront. That happened independently, and it was addressed first in the opinion. Personally, I believe that the amount in controversy issue is secondary to the existence of the valid arbitration agreement, and the valid arbitration agreement is enough to have the case removed. It's enough to have the motion granted.
But do you think the trial court was wrong then?
Do I think the trial court was wrong? I do not.
Subject matter jurisdiction?
I do not think the trial court was wrong. I don't think that that is the primary grounds to have the motion granted. If you'd like, I can walk you through the math, but assuming you guys are like me and became attorneys to avoid math, I will not do that. But essentially, we're talking about a difference in interpretation of $5,412.08. I don't think that it's in dispute that that number, regardless of what appellant may believe his actual damages are or anything like that, that number is in fact below the statutory jurisdiction amount. Sufficient?
Yep.
Thank you all.
Thank you very much. Counsel?
Thank you, Your Honors. I echo the sentiments of counsel.
I'm sorry, you're Mr. Pocarelli, is that right?
Yes, Your Honor.
Okay, just wanted your appearance.
Oh, I'm sorry. Yes. Jacob Porcerelli on behalf of AFSCME Local 1659, the individual union defendants as well, who are now union appellees. Like I was saying, I echo the sentiments of counsel from Wayne County. With this particular issue, we filed concurrent motions for summary disposition. The subject matter jurisdiction argument was put forth by the union. But ultimately, the judge also found that both defendants in this instance, so both appellees, were entitled to summary disposition pursuant to C7 because the arbitration agreement applied to all of us. Appellant's biggest argument is that the union allegedly waived arbitration, and that's why he's permitted to proceed in court somehow. But that burden is on him, and he has failed to meet it. The evidence put forth in his brief does not demonstrate that arbitration was waived, and the remaining claims that he has fail as a matter of law. So I know he's upset that the motion for what he referred to as a motion for partial summary judgment that was brought under C9 and C10 was dismissed, but neither of the appellees brought forth answers. They were motions, so those do not count as pleadings under court rules and case law. And so that was procedurally improper. And then, his other motion or his other arguments in the motions that there was no genuine issue of material fact, like counsel from Wayne County aptly put in their brief, it's premature, but also, just as a matter of substance, it does fail. An IIED claim cannot be rooted in a contract breach, and the civil conspiracy has to have an underlying tort, and contract breach is not that as well. So for all of those reasons, the trial court's decision should be affirmed.
Thank you. Any questions? Thank you very much. Mr. Conway, you have time for rebuttal.
Thank you so much. Okay, so first, I would like to state that whereas counsel for the county indicated paragraph 9 of the settlement agreement should rule or control with the arbitration clause therein. However, that falls under the illusory remedy doctrine. As the papers show, there has never been any arbitration procedure post-employment by the union. Therefore, there is no process by which arbitration can take place. The union indicated, and evidence was provided from the union president indicating that they had never done it. In conversations with union representative at the state level, they further indicated, and it's in the record as evidence, that this has never happened. And in order for a procedure to be instituted, it would have to go through a number of hoops in order for that to happen. What indicates the union's non-willingness and thus constructive waiver of arbitration is the email from the president indicating that they were done with the issue and would not revisit it. The subsequent claims with regard to the subject matter jurisdictional issue, which the judge agreed with counsel by limiting it to what they believed the contract would yield. However, we have two tort claims that must be under Michigan law separated and determined on their own merits, which both indicate that the amount in controversy would be above and beyond $25,000. And where they want to predicate those tort claims on the contract breach, the complaint on its face in and of itself clearly indicates it is not based on the breach. It is based on the conduct of the defendants after the breach and that impact on me as the plaintiff in this particular case. So we're not talking about something, a conspiracy that resulted from breach. We're not talking about IIED that resulted from breach. We're talking about that behavior that occurred after, post-breach. When I tried to contact them, nobody responded. And the record will reflect that the only time that either the county or the union responded was after I filed suit. And they then let me know, the union let me know in writing, we don't have a post settlement process for arbitration. So we wouldn't be doing that. However, as the county pointed out in paragraph 9, the collective bargaining agreement indicates that this arbitration procedure has to follow the CBA. There is no post-arbitration procedure in the CBA, which makes it fall under the illusory remedy doctrine. There's no remedy available, which is why I had to go to court. I believe, in conclusion, based on the fact that the court did dismiss by subsuming the tort issues into the contract issue without actually taking the complaint for as true as the law indicates they should have, and dismissing the case without even considering the merits. And with that, I'd like to thank the court for its time.
Thank you, Mr. Conway. Appreciate your being here and your arguments today and your briefs as well.
Thank you.
And what we will do from here, just so you know, is we will, we've been studying your case, but we'll continue to do that and make a decision as soon as we can and issue a written opinion.
Thank you.
All right. Thank you all.
Thank you.
Case is submitted. Moving to item 21, consolidated cases 371505 and 371506 in Ray T. Schmiege minor. Is anyone here for that? All right. Those cases will be submitted on the briefs. And the remaining 3 items, similarly, no one is endorsed. Item 22, case number 372689, in Ray J.C. Sherman minor. Item 24, case number 375724, in Ray D.L.N. Murphy minor. And item 25, case number 372624, in Ray Guy minors. All will be submitted on the briefs. And that concludes our case call.